Welcome to K-Talk. I am Professor O'Gorman from Barry University School of Law.
I'm Steve Maxwell from the University of Miami School of Law.
And on this very dark episode of K-Talk, perhaps our darkest yet, we're going to discuss something called the parole evidence rule.
It's fitting for a dark episode, isn't it?
It is, and I was given a little bit of time there. That pause was because I figured that there would be a few gasps, screams. I wanted it to die down, try to get the listeners calm before we proceed. So this is a quote, Steve, a famous quote about the parole evidence rule. Few things in our law are darker than this or fuller of subtle difficulties. This should be a fun episode, don't you think?
Oh, absolutely. With a lead in like that, how can it, what can go wrong?
We've been avoiding this for as long as we can, Steve. I think we just got to do it. We got to do it.
Yeah. We can always check in with our parole evidence officer.
Excellent. Now, Steve, this is an important thing you just said, because right off the bat, we want to make sure that our drop the E.
There you go. Drop the E. And I had trouble with that one too.
Well, it is, it's easy to put an E on there. I mean, I've seen people slip up, academics slip up and put an E. I mean, this happens. It's a parole with an E, of course, means that we're talking about what a release from prison. Maybe there is such a thing as a parole evidence rule with an E dealing with, is this admissible in a parole hearing? I don't know. But that's not our parole evidence rule for contract law. It drops the E. Parole, think of parole as oral, or importantly for us, think of it more as informal evidence. But so today, is the parole evidence rule a doctrine which does seem to scare students? They struggle with it. Steve, do you find this to be true as well?
Absolutely. And I think right about this time of the semester, you're in the home stretch and there's so much law in your head, so many doctrines you've talked about that they do bleed together and it's hard to differentiate. I think at this point, the hardest thing for a student is making those hard line distinctions between different doctrines, and keeping things separate is truly the challenge at this point.
It is a challenge. And I noticed this with my students, is that anytime there is parole evidence of any kind floating around, they will think the parole evidence rule should be brought in and has some role to play here. And they forget that it is the parole evidence rule deals with certain things. It is not sort of this all-encompassing doctrine, which anytime there is so-called extrinsic evidence that you need to drop this rule down and use it, it's going to have limited application. And so you're absolutely right. One of the things that we want to do here in this podcast is make sure that students understand when you should bring the parole evidence rule out to do its work and when you want to keep it in the closet and not bring it out. Okay, so let's get on the table. Enough beating around the bush. Let's get out the doctrine. What is the parole evidence rule? So the parole evidence rule in general is this rule that when the parties enter into a written contract, as a general matter, the parole evidence rule is going to provide that any promises, any agreements that came at the time of entering into the written contract or before entering into the written contract that aren't included in the written contract are discharged, are gone, are not considered part of the party's deal. How did I do?
You did great. And I want to start one of those hard line distinctions from that definition. And this is where students really have to parse this rule. And what I mean by parse is every little bit of that rule is really important. And if you just get one part at a time, you're going to do great. Just do one thing. And so one of the things that you as a student need to know and realize is that where there is no written contract, there's no parole evidence issue. And I think that's one of those hard line distinctions that the students need to be aware of. If it's just an oral contract, parole evidence is not going to enter into your essay at all.
It's a terrible name for the doctrine for a couple reasons. And you make me think of this as you're explaining that, which is that, the parole evidence rule, maybe a better name for it in one respect would be the written contract rule. Because you're absolutely right. You need a written contract. If you don't have a written contract, the parole evidence rule is not in play. And does it sound like this rule likes parole evidence? Oh, hey, I'm the parole evidence rule. But the parole evidence rule hates parole evidence. It probably should be called the anti-parole evidence rule. So right off the bat, I think the name itself might cause a little bit of confusion with students.
Yeah, sure. And one other little weird detail that I want to ask you, Dan, is it parole or parol?
I say parole. Now, I think, I got to tell you, there's a lot of things that I've looked up in my time, and I've forgotten what the answer was when I looked it up. I got to tell you, when I was a younger man, Steve, a younger academic, I had more energy to delve into these issues. It bothered me more. I think my recollection is that either is actually okay. This tends to be the case, doesn't it? That usually either is okay.
Yeah.
I think most people say parole evidence rule, which is probably an Americanized, way to say it. My recollection is you can say it either way. Now, the good news for students is it's not an oral exam. It's a written, speaking of oral versus written, it's a written exam. So the most important thing in my mind is I don't care how you say it. I don't care how you think it, but I want you to drop the E. No, I'm not going to ding you if you don't have the E, but I don't know. You might get a grumpy bar exam grader who you're right on the edge and they remember that E and it bothers them. It'd be worse is if they thought it was supposed to be an E and they were dinging you because you didn't put an E.
That would be, I could see that happening.
Let's hope not. None of us are perfect, Steve. So the parole evidence. So I'm going to say parole evidence. So Steve, if you want to say parole, because look, you're dressed nice. You look like you and I am too, but we look like maybe would say parole evidence. If you want to have that affectation, I have no problem with it. So let's talk about some of the basics of the parole evidence rule. And let's talk about why we have it. I really believe that students would struggle less with the parole evidence rule if they simply wrap their brain around why we have it. If you understand its functions. And the reason why I think this should be easy for students is because you don't need to be a lawyer to understand this. I think most lay people understand this concept. If you ask people, why did you put your contract in writing? What was your purpose to put it in writing? What would they usually say, Steve? Do you think if I just, I stopped somebody at the mall and asked them that? What would they say?
Because they want it in writing so that everybody can see what the terms of the contract are and there's no confusion, to keep any kind of misperceptions out of their dealings.
Exactly right. And you're being very nice because I'm also concerned about liars. I'm a little more jaded.
Right? You're a grumpy professor.
I am. Yes. I get off my classroom or something, whatever. Yeah. So to avoid confusion and to avoid claims that there was something in the deal. So whether the person is truly misperceiving it or they're fabricating it, you want to protect yourself and protect, that these are the terms of our deal. People aren't going to be saying there was this, there was that. Let's get it all in writing. And once you understand that that's why people tend to reduce agreements to written form, the parole evidence rule makes a lot of sense. I mean, the parole evidence rule is your buddy. I mean, if that's your purpose, but we didn't have a parole evidence rule, it sort of would it wouldn't build up and support your purpose in reducing it to writing. So the parole evidence rule is really not a bad guy. If you think about it, I mean, the parole evidence rule is just saying, hey, I'm doing what I thought you guys wanted me to do. Don't you want me?
Yeah, you make us feel sympathetic to the parole evidence rule now, which I like because it's less dark that way. It's more your friend.
I'm trying to lighten the mood. Okay, so let's talk about the parole evidence rule. So as Steve has mentioned, first off, you've got to have some sort of writing. And in addition to that, And these are kind of easy things that are easy to ask on multiple choice questions because they're black and white before we get to those subtle difficulties or difficult subtleties. Not sure which one it was. Let's talk about some of the easy ones, black and white ones. A parole evidence rule only arises if you're dealing obviously with what we call extrinsic evidence, meaning evidence, terms or agreements that were not included in the writing. That's what we mean by the word extrinsic. In contract law, when we say extrinsic versus intrinsic, is it in the writing? People usually don't use the word intrinsic. I think a lot of contract professors do. Intrinsic means, hey, that term is in the writing. Extrinsic means it's not in the writing. So that's number one. Number two, the parole evidence rule only applies to extrinsic promises or agreements that were made at the time of the writing or before, not to agreements after the writing is created.
And that's a big, good, hard line distinction. And where I see, and Dan, I'm so glad you're identifying that as one of those hard line distinctions. After that moment of contract formation, maybe you're looking at an attempted modification. And so it's important for you as a student, draw that hard line at contract formation or prior. That's all the parole evidence. If it's anything after that, I look to another. Is there something else they ought to look for after in terms of modification or some other issue, Dan?
Oh, there sure is. So I have good news and I have bad news. So the good news is if it happened after reducing to a writing, we call this integrating. So when I say we haven't talked about what an integration is, but if it's post-integration, post-writing, then the good news is you don't have to worry about the parole evidence rule. You don't even talk about the parole evidence rule. To talk about the parole evidence rule would really be a mistake unless you're simply writing that the parole evidence rule doesn't apply here because it happened post-integration. The bad news is there's, of course, other issues that arise. And you've really pointed out the main issue, which is this would be viewed presumably as an attempted modification of the agreement. And that's going to then bring into play all of these issues of when is a modification legally binding? We know our general rule is that you need to have consideration in order to have a modification be binding. We know, of course, there are a series of exceptions to that. The most notable, perhaps, being Article 2 of the UCC does not require consideration to make the modification binding. It only has to be made in good faith. We know even the common law has this so-called unanticipated circumstances doctrine. So there are a variety of issues that are going to arise with respect to whether the modification is binding, but it is not a parole evidence rule. And let me point out one other one, which looks like a parole evidence rule, but isn't. Contracts often have a clause saying that any modification to be legally binding must be in writing and perhaps signed by the parties. And let's say you have an oral modification. That's not a parole evidence rule issue. It's not even really itself a statute of frauds issue. It's a, hey, has a condition to an effective modification occurred? Maybe it's been waived. But so these are all separate issues, not parole evidence rule issues. And the answer to your question is, oh yeah. There's lots of ugliness on that other side. The good news is on today's podcast, we don't have to invite that ugliness in to the show.
Yeah, awesome. But I do think it's helpful for a student to know to make those hard line distinctions. And I think we're driving this point home beautifully, I think, because I know that confused me as I was first relearning contracts in order to teach it for my bar class.
And it makes sense. So I am a proponent of letting students know why we have rules. To the extent we know some common law rules, you're kind of like, I don't know, right? I mean, because we've had it this way for 100 years, and then why we have this kind of lost to the mists of time. But we do know certain things, and I think it helps to know why we have a rule to help understand it. And if you think of the parole evidence rule as sort of implementing what we think the parties likely intended, that when they reduce an agreement to writing, we assume they're doing that because they want to, as you noted, avoid confusion, or as I noted, perhaps avoid someone lying about the deal. And if that's true, that says nothing about trying to prevent the future. It's about avoiding allegations about what happened in the past and what happened at the time of integration. If you're not trying to prevent modifications, you could try to prevent modifications and have a provision saying we've got to have any modification assigned writing, but that's a different provision. So if you remember the purpose of the parole evidence rule, it will help you remember that it shouldn't have any application to an attempted modification, because that's not why people, you said, well, why are you putting this contract in writing? Well, putting in writing because we want to prevent modifications in the future. Huh? That's a non sequitur. It makes no sense. So let's talk about some of the other things that we know that are kind of black and white. So let's talk about contemporaneous versus prior. This is a weird one to me, Steve. I'm sort of the camp that I don't know how you can have a contemporaneous extrinsic agreement, because to me, you form the contract at an instant, and I guess we could have lots of debates about that. But to me, it's like, let's say I sign a contract, I slide it over to you, and then you sign it. The minute you sign that, flounder, whatever. you sign that thing. I shouldn't complicate things. You sign it, Steve Maxwell. That's a different show. You sign it. The trap is sprung. We've got an acceptance. I'm assuming, we're face to face. I don't want to talk about the mailbox rule. That's another podcast. You sign it. In an instant, the trap is sprung. And to me, if we had just, right before you sign it, you'd said to me, oh, Dan, by the way, will you agree to destroy the ice house across the street? And I say, yes. And then you sign it. I don't view that as contemporaneous, because even if it's seconds before, but there is this notion that this idea that there's also contemporaneous agreements that are extrinsic, not only prior ones. And I go with that because just people talk that way, and that's fine. But there is actually an important distinction here between the contemporaneous versus prior. And this is the distinction between extrinsic written agreements and extrinsic oral agreements. Now, I know right off the bat, students may be listening saying, wait, what are you talking about? What do you mean extrinsic written agreements? The parole evidence rule can't apply to extrinsic written agreements. I mean, it's the parole evidence rule. Doesn't the parole evidence rule only apply to extrinsic oral agreements? And the answer to that is no. The parole evidence rule applies to any extrinsic agreements, not just written, not just oral. It can also be written, assuming it's contemporaneous or before. But here's where there is some distinction. And maybe before I talk about the distinction, let me clarify how the parole evidence rule could apply to a prior written extrinsic agreement. Because I think most people view the typical parole evidence rule issue as, Steve, we've been negotiating for a couple of days about the sale of my parcel of land, and you want to buy the parcel of land, but you're hesitating. And you're like, well, Dan, maybe if you destroy that ice house across the street, that unsightly ice house across the street, I would buy your parcel of land. And I say, well, I do happen to own the ice house across the street, so you're in luck. I don't have to, commit a trespass and a crime to destroy it. I actually do have the legal right to destroy it. And yeah, if you enter into this contract, I will destroy the ice house. And then 2 days, we keep negotiating and the price adjusts a little and we reach a deal. We haven't talked about the ice house again. And then you sign the contract, and the written contract is no reference to my agreement to destroy the ice house. So that is that's your classic parole evidence rule issue, which is, should this extrinsic oral agreement to destroy the ice house be considered discharged, overridden, superseded by the written contract? And most people would recognize that quite quickly. We have a parole evidence rule issue here. Let's change it up a little bit. Let's say that I am offering to sell you a plane, and this is based on a real case. And I send you a proposed contract. I send you an offer, and there's a cover letter. And I talk about how amazing this plane is. And in the cover letter, I say, this plane has X amount of gas mileage. And you say, that's great. And you sign the contract, you send it back to me. I sign the contract. And let's say that contract has a merger clause, which really isn't necessary for this hypo. But there's no reference in the written contract, to the gas mileage that was referred to in the cover letter. This too is a parole evidence rule issue. It's very possible that that written warranty that the plane would have X gas mileage was discharged by the parole evidence rule because it did not get included in the writing. And notice what's going on here is this is not a concern about anyone lying, like I was suggesting, because it's in writing. I'm not denying that I warranted it would have this gas mileage, but there is a possibility that the court's going to assume we intended to let that warranty go because it was not included in the writing. So a written extrinsic promise or agreement is subject to the parole evidence rule, just like an oral one is, but there's an exception. And I know it's been a long time coming. The exception is when we have a single transaction. Let's say I'm selling you a business and we've got 3 or 4 contracts that are part of that transaction. We've got, a sale of the land. We've got maybe a sale of the assets. Maybe we've got like a trade secrets agreement, whatever. Just they're all part of the same transaction. Well, unless you've got some machine, like remember, I think was it Thomas Jefferson who had that machine with the pen and the pen? He could make a copy of his letters. He would write over here and the pen would be over there, another pen. And as he wrote, it would create a duplicate. Now, unless you have something like that, and you're actually signing, you line up the 4 contracts and you sign them all at the same time, one of those is going to be first, then you're going to sign number 2, then you can sign number 3, then you can sign number 4. Well, the law views these as basically being signed contemporaneously, all in one sitting, all essentially at the same time. If you have multiple writings that are considered part of the same transaction that are being signed contemporaneously, using that word loosely, don't ask me how loosely, but loosely at the same closing, let's say, they are presumed to be a single agreement. So nothing is extrinsic to anything else. They're considered one. And so that way, when you get the merger clause in number 4, it doesn't destroy contracts 1, 2, and 3. Whereas if it's an oral agreement right before you sign, it is extrinsic and subject to the parole evidence rule.
And Dan, as you were talking, it made me think maybe here's a reason why the rule talks about contemporaneous and prior, because I could see something being presented at a closing in an oral way. And the argument say, well, that happened at the time of contracting, not prior to, so that shouldn't, fall under the rule. And so maybe that's why the rule has both covered.
I agree completely, because if you think about it, the parole evidence rule is not going to be concerned about contemporaneous written, but I think the parole evidence rule is very concerned about the guy who, right as he's getting ready to sign it, says, Steve, will you agree to throw this in? Sweeten the pot a little, just help me decide to sign this. And like, you got it. And I'm like, excellent. And I sign it. So that could happen a lot. And I think the parole evidence was very concerned that people would come along and say that, hey, right at closing, they promised me this. Now, what's interesting about it though is, I'm not aware of a rule that says that if there is that oral agreement right after signing it, that it is somehow subject to the parole evidence rule. Because it seems to me that it is a pretty clear line. So if I sign it and then I say, well, Steve, I'll sign this and you sign it, but you know what, would you also just agree to destroy the ice house? I'm not aware of anything, that would say, well, that's a parole evidence rule. That sounds to me like a modification issue. I mean, odds are it's an unenforceable modification because there's no additional consideration. If it's sale of goods, now it's different. But so I think that, that timing again is very important. Okay. So other things about the parole evidence rule before we get into the details of figuring out when it actually applies.
I do want to say one last thing because we're talking about written agreements prior to or at closing. And I do want to say one thing about where I've seen this tested on the Florida bar exam and writings going back and forth that constitute sort of pre-contract negotiations. And I want to flag that too, because those aren't really agreements. They're just one proposal going this way, a proposal going that way, counter and this, that, and the other. And so there was a lot of that business. And so that was the signal on that bar exam to talk about the parole evidence rule.
Yeah, absolutely. So the nice thing about the parole evidence rule is that even if let's say you've got this preliminary negotiation stuff, there's a very strong argument that those were never agreements. Those were never promises. That it was just talk. But the nice thing about the parole evidence rule is that the parole evidence rule is going to come along and say, look, it's really not all that important to me, parole evidence rule, whether this rose to the level of a promise or an agreement, or it was just talk. Because even if it did rise to the level of a promise or an agreement, I'm going to come in and assuming I operate, I'm going to discharge it. Obviously, the parole evidence rule really doesn't matter, I guess, technically, unless it otherwise would be considered binding or an agreement, because the parole evidence rule discharges stuff that would otherwise be binding. If it's not otherwise binding, the parole evidence rule doesn't have any work to do. But the nice thing again about the parole evidence rule is you don't have to ask those questions, because even if you were binding, it's going to come in and it is going to discharge them. So I agree completely with you. If you see negotiations going back and forth and you're not sure if that even rises to the level of a promise or an agreement, you should still bring out that parole evidence rule. And I think the bar examiners are absolutely expecting you to do that, because it is going to generally be the way it would be analyzed, as opposed to maybe getting into a big analysis of, well, was it really a deal or not a deal? Because the parole evidence rule is designed to encompass all that as well. The parole evidence rule is about, we believe that when the parties integrate, reduce it to a writing, that they're intending to, in general, let go of all that stuff that was talked about in negotiations and that didn't make it into the writing. So the parole evidence rule is sort of like taking that idea that it probably was just talk if it doesn't make it into the writing. So you're absolutely right. You see preliminary negotiations, terms being thrown around, they don't make it into the writing, it's a parole evidence rule issue and you'd want to apply it. Okay, so some of the other issues on the parole evidence rule is the court is going to apply this. Now, I don't know how important that is for law students as opposed to the real world practice of law, where you care very much about who's deciding issues. Is it the judge or is it the jury? What's very interesting about the parole evidence rule is that the parole evidence rule is decided by the judge. And I think this is something that students don't appreciate a lot, which is this idea that the parole evidence rule generally assumes that the promise has been made. The parole evidence rule, for the most part, and there are some courts that I think will look to see, well, do we think there's a lot of evidence it was made? But in general, courts assume that when they apply the parole evidence rule, they assume that the agreement was made. So if I promise to destroy the ice house, You claim I promised to destroy the ice house during negotiations. It's not included in the writing. If I'm going to raise a parole evidence rule to try to argue that even if I had made the promise, it was discharged, when the court applies the rule, it's going to assume that I made the promise. It's not going to go fact finder on it and start, crossing, testing my credibility and stuff like that. So the parole evidence rule is this sort of the court being a gatekeeper on the possibility that, number one, this evidence is being fabricated or the party's not really understanding it. That's if it's oral. Or if it's written, whether or not, or if it's written or oral, or perhaps do we feel like the party's probably intended to supersede it? And if you think what's interesting about it is that it reflects a certain level of distrust of the jury. This idea that the jury can't be trusted to decide whether it actually was said or whether the parties intended it to be overridden. It's almost like the court is coming along and saying, look, I got to protect the party who is arguing that they never said it or that the parties intended it to be superseded. I can't just hand this issue to the jury. They can't be trusted. They're going to like the little guy. They're going to feel bad for the little guy. And so the parole evidence rule is going to be applied by the judge. If the judge opens the gate and says the parole evidence rule didn't discharge the promise or agreement, then it is left to the jury to decide whether or not the promise or the agreement was actually made.
And that actually makes a lot of sense, because can you imagine being on a jury and some things that happened at the time or prior to contract, and this just sounds like a bad deal and really unfair, and you feel so sympathetic toward the party that's going to lose under the rule? Could you really go, I just don't think the ordinary juror can do that sort of thing.
Well, that's the concern. And I'm sure there's probably people out there who disagree with that and are like, hey, what happened to our jury system? Shouldn't the jury get to decide this? Why are you keeping stuff from the juries? Because they can't be trusted with this. But that's what the parole evidence rule does. And so keep that in mind, that it doesn't, just because you survive a parole evidence rule argument against you. So the parole evidence rule doesn't discharge, let's say, my promise to destroy the ice house. That doesn't mean that you plaintiff are home free. The jury could decide that the parties actually intended it to not survive. A jury can decide that they don't think the promise was actually made. They can do either of those. It's just that you got to pass two hurdles. You got to get by the judge first. The judge is sort of a check on things, a little bit like the statute of frauds kind of is a check on whether an agreement was actually made when it's oral. So, okay. So Steve, enough. Let's get to applying this thing, right? Let's get to the darkness, right? And the subtleties of it. Okay. So you noted that the parole evidence rule doesn't apply unless you have a writing. All right. Let's give this a fancy word, Steve. Let's call this an integration.
That's just to make it easy, right? A new word.
You know what it is? I'll tell you what it is, Steve. Students should be thrilled with this. It is so that way we have a secret language as lawyers, right?
Yeah, totally.
To be a member of the club. And it'll allow you, Steve, this is great. What this will do, this will allow law students, lawyers, judges to immediately identify somebody as a non-lawyer. And so we should be thrilled with this. Welcome to the club. Use this secret language. And so we call this an integration. Okay. It kind of makes sense though. So it's when you think of word to integrate, so what do you think, any sense of why we would use this word integrate when we're talking about a writing that will bring forth the parole evidence rule?
Yeah, when I think integrated, I think of together. all together. This is an integrated, you know, integrity is doing the right thing when nobody's watching. This is like a whole complete person who's not one way in this and another way in that other context. And so I think of togetherness when I think integration. If you think of the opposite, a disintegration, that's coming apart, that's separateness.
I love that. I never, that'd be great. So yeah, so the opposite of an integrated agreement is a disintegrated agreement.
Sounds even more dark, sinister. It's like a crime.
It sounds like a band. Disintegrated agreement. We are disintegrated agreement. Hello.
I like that. A contracts band.
Yeah, disintegrated agreement. Yes, that's right. To integrate, to bring together. So if you think about why do we have this fancy name, it sort of makes sense. It's this idea that we are bringing the terms together. We're trying to take our agreement that we've had, that is, let's say, oral, and put it together in written form. So you have to have something called an integrated agreement. So if you're trying to show off to your law professor when you're taking a final exam, and let me tell you, it's not a bad idea. Pretty good advice, right? You don't want to show off when it's not relevant. Like, hey, there's no parole evidence rule here, so let me show off and tell my professor everything I know about the parole evidence rule. That's bad showing off. But good showing off is saying the parole evidence rule only applies when there is an integrated agreement. And let's talk about what that means. So integrated means to reduce to writing. Actually, I don't mean, if you look up the law, a dictionary, integrated is not going to say in writing, but that's what we mean. When we say integrated, we mean to collect it, to bring it together, as you were noting, into written form. So that's the key part, right? You start out talking about that in this podcast. Integration means to bring together, to reduce the terms into written form. It also has to be an integrated agreement, which means that both parties must manifest assent to the integration, to the writing. And if you think about it, this makes total sense. Remember the purpose of the parole evidence rule and why we think people integrate. They're integrating, and the parole evidence rule is supporting this, because we believe that parties are reducing it to writing because they want to avoid confusion. They want to agree that these are our terms, and no one's going to come back later and say, no, the terms were different. If that's the purpose, it makes no sense to think that you could have an integrated agreement for purposes of the parole evidence rule if only one person assented to it. Could you imagine, Steve, if I was like, you're like, hey, this was our deal. I'm like, oh, this was not our deal. Do you remember this written contract? And you're like, no, I've never seen it. Like, yeah, I didn't send it to you. I drafted it and signed it and kept it. But yeah, this is our deal, because I integrated on my own. I just forgot to tell you. That makes sense.
Not in the least. But I'll tell you, it's always hard to see in the heat of an exam. If you're under, pressure, you haven't slept well, that's where a prof can really zing you.
You're walking out of the exam like, wait, oh my gosh, the other side didn't assent to it. Oh my God, it's too late, right? It's the kind of thing you realize as you're driving home. Did they wait, the other side didn't assent to it. So yeah, that happens. Absolutely true. So it has to be written, and it has to be assented to by both parties. Now, what the assent does not have to be is it does not have to take the form of a signature. So when you are learning about something called the statute of frauds, one of the things that you're going to want to do is try to keep in mind the distinctions between the parole evidence rule and the statute of frauds. And whereas the statute of frauds is going to demand a writing that is signed by the party to be charged, which we're not going to digress into that, because that's a whole nother podcast or podcasts. Under the parole evidence rule, the parties just have to each manifest assent to the writing. It's typically by signing. I mean, that's clearly assent. So I write a contract up, we both sign it, easy. But this is where it can be tough on students. Oh, Steve, I'm going to be so mean to you in this transaction. It's going to be so awful for you. What I'm going to do, they'll come back to bite me, actually, in some cases. we're going to enter into an oral contract. And the trap is sprung. So note that oftentimes integration can happen post-contract formation. So the extrinsic terms have to come before that, right? So we can have an oral agreement, and then we might integrate after. It's not always we reach the oral agreement and then integrate at the same time. I'm going to send you a letter of confirmation. Yeah.
That's always how you zing somebody.
Oh, that's a good one, right?
Yeah.
And so what I'm going to do is, now this could hurt me if this is within the statute of frauds, because I'm going to sign this letter. So now if it's within the statute of frauds, you could use the writing against me. And if you don't sign it, I can't use it against you. But let's talk parole evidence rule. So I send a written confirmation and I sign the written confirmation. And I send it to you. If you sit on that letter, you don't object to it. You don't call me up and say, hey, what? Those terms are all wrong. No, no, no. Where's the ice house promise? You never do that. You sit on it and you never object. At a certain point, the court is going to infer from your silence that you have assented to the writing. Now note, this is not silence as acceptance of an offer. We've already formed a contract. This is something a little distinct. This is silence as agreeing, as assenting to the writing for the purposes of the parole evidence rule. But what it means then is, since you don't have to sign it, I don't know how long you got to sit on this thing to assent. I have no idea. But if you, at a certain point, if you sat on this long enough, the court's going to infer that you've assented to the writing. And now, voila, that is an integrated agreement for purposes of the parole evidence rule. And the nastiness of that now is if I excluded something that was favorable to you, then it could actually be discharged under the parole evidence rule. Now, there's something very, very nasty going on here as to whether this is a modification that doesn't have consideration. I don't want to go there because I don't think most professors will go there. It's very much in the weeds. So I think it's not worth talking about. But what I think is important is that students recognize the signed letter of confirmation trailing. It's always trailing because you're confirming something that's happened. The trailing letter of confirmation that the person doesn't object to, who receives it, can become an integrated agreement. And if they didn't speak up, they could be in trouble because the promises that aren't in there that were favorable to them may be discharged under the parole evidence rule. What do you think?
Now, Dan, I've got a thought here because the way I teach it, I talk about it about, at or contemporaneous with the agreement or prior to, and that feels like an exception to that part of the rule where, the integration comes after formation. Like, am I understanding that right? Or do I have something wrong?
No, you have it right. But keep in mind, the contemporaneous or prior to is contemporaneous or prior to integration.
So that's where my problem of my definition is then, because I was thinking prior to or at the time of contract formation, and that might be a bad way to state the rule. Am I right?
Yes, because think about it. We could be sitting there and talking about this and reach a deal, pull out a piece of paper, type it up as a contract. Parole evidence rule is applying, right? Would anyone doubt that the parole evidence rule applies in that situation? So now you're really just talking about a difference in time, that it comes later. So yeah, it is. If you have an integrated agreement, the integrated agreement is what potentially does the discharging. And so the integrated agreement does not have to be contemporaneous with the formation of the contract. Now, my guess is this doesn't come up a lot. I mean, my guess is it's not a heavily bar tested thing. I don't think students should probably spend a lot of time worrying about this, because I think most of the time you're going to see your classic situation that you brought out, which is there's a series of negotiations, things are talked about, things are promised, tentative agreements are reached, and then at the same time that you form a contract, you integrate. The integration and the formation is at the same time. And that's then there's no concern about it at all. But just be aware that you should be talking about the parole evidence rule if you have a a integration occurring after formation of the oral contract. And if you think about it, it sort of makes sense, doesn't it? Because what's the point of the written confirmation? The written confirmation is a little different than what we were talking about with your classic integration, where we both sign a contract, because then it's like we're both sort of manifesting this intention to make this our deal and override stuff that wasn't included. Whereas the written confirmation looks a little more unilateral. It's more like, well, one party is trying to integrate and the other side is not, and they're now being dinged because they don't say anything. So it looks different, but you should still be talking about the parole evidence. Anytime you see the parties agreeing to a writing, which has at least some terms that are part of the final deal, that's an integration, irrespective of the point in time, how closely connected it is to formation.
Got it. I appreciate that, because I learned something new there.
Well, it's nasty. I've actually seen it. I teach a case, Lurie Brothers dealing with the sale of steel, and the party who confirmed it, they were the one that left out the term favorable to themselves.
So boy, but you know what? There's no crying in contracts. Who had the best opportunity to prevent that from happening?
Absolutely right. They'd failed to include, they promised steel, and during negotiations, they claimed that they had told the buyer, look, I'm having a supply chain problem. My supplier is unreliable. And if I can't get the steel from my supplier, I don't want to hassle. Okay. And the buyer's like, yeah, no worries. And then you can see this coming. He sends the written confirmation. It doesn't have the condition about only if I get it from my supplier. And then you can see this coming. He doesn't get it from his supplier. And then the buyer sues. And the seller's like, whoa, I told you, we agreed. And the buyer's like, yeah, but that's an integration. And it's not in there, and it's discharged under the parole evidence rule. And so the seller actually was harmed by their own desire to confirm. So I guess the point of that is you're going to confirm, get it right. At least your stuff, get it right. But if you think about it, it kind of makes sense to apply the parole evidence rule to written confirmation, I think. Because what's the point of the confirmation?
Right.
Right. I mean, that's the whole point. I'm writing to confirm this deal. You should speak up. If you're the buyer, in this case, the offeree or whatever, or the party receiving the letter, I'm trying to say, look, I'm trying to confirm this. The time for you to speak up is now, because I'm trying to avoid a misunderstanding. So I kind of see it.
Yeah, no, I do too. And what you're mentioning, though, does make me think of a previous podcast where we're talking about contract law isn't about gotcha law. And this feels like one of those scenarios where you really could have a gotcha right here.
Well, is it really, Steve, is it really a gotcha? I mean, I said I'm confirming this. Is it really a gotcha? I gave you the chance, Steve. Come on.
It's true, but if that was like your practice of sending a little gotcha and you knew 1 out of 10 was going to be a successful gotcha and a lucrative gotcha, I can see somebody doing that a bit.
Yeah, well, I guess it all depends on when you think it's a gotcha and when you don't think it's a gotcha, right? So, all right, but let's keep moving along then. So, step 1: is there an integrated agreement? This just means, is there a writing that includes at least some terms that are final that each party has manifested assent to? Doesn't have to be signed by anybody. So, if it was just a letter that was this explaining the status of negotiations, that's not an integrated agreement because it doesn't include at least some of the terms that are final. Because students often ask, well, what writing wouldn't be integrated? Well, that might be that, like just to confirm our status for negotiations, because you may not want to have to start anew. Everyone knows you don't have a deal yet. It's preliminary negotiations, but maybe we've got like 20 things to talk about, and we've made it through 10. And we know we got 10 left before we got a deal. So it's just preliminary negotiations, but we don't want to forget where we were at. So I just say, okay, this is to confirm that we've reached an agreement on 10 of these terms. And even though I'm saying agreement, no one thinks that it's anything other than preliminary negotiations. I'm using that term loosely to mean that this is our status of negotiations. And so we don't forget, we got a record of it. That's not an integrated agreement because it is not indicating any terms that are in fact final. So an offer letter is not going to be an integrated agreement because none of those terms are final yet. It's not been accepted at that point. Now, assuming you accept the offer, well, that's a different story, right? So now you could potentially, right? You're assenting to that writing potentially. Okay. So, let's talk about an exception that I like to think of it as meaning there's no integrated agreement yet. This is just the way I think about it. Not everyone else does. This is something called the conditional delivery exception. So the conditional delivery exception applies in the following type of situation. I'm going to use a famous case, Pym versus Campbell, I believe was the name of it. I used to teach. It's a wonderful case, but you got to let some of them go. There's not enough time for all of them. So Pym versus Campbell, I believe I created an invention, Steve. This is very Shark Tank-ish. I had created a device for washing. It was a washing machine, but it was like for washing minerals or something like that, not clothes. And I was very fond of it, but I needed investors. And so you're a shark, basically. And so I come to you and I say, hey, Steve, look at this machine I've got. And you're like, yeah, okay, I might be interested in investing, but I don't know anything about machines that wash minerals. I'll invest, but I'm only going to invest if two independent experts agree that this machine is good. And I say, deal, no problem. And so let's say that we agree to have these two experts arrive and meet us at Denny's, which of course is, I think, where we would do this deal probably, right? So, because they'll let you sit for a while, won't they?
And you can do it at 3 a.m. too. So
yes,
it's flexible.
They're not going to get angry, are they, about us wanting to move the table?
No, you can do whatever you want in there.
Yeah, it's like a high-end restaurant. They're like, I mean, it'd be nice, the high-end restaurant, but they're like, like at 8 o'clock. So, okay, so it's 3 a.m. We're at Denny's, and the two experts are supposed to show up. And Steve, only one expert shows up because the other expert thought it was supposed to be obviously 3 p.m. This guy's like asleep. He's like 3 a.m. Who would schedule this for 3 a.m.? And so only one expert shows up. And this one expert says, this machine is amazing. This is awesome. And so you, Steve, though, you say in between bites of, I assume you're probably having breakfast. Is that what you get?
Yeah, I'd get an omelet.
In between your omelet, bites of your omelet, you say, well, look, I'm sorry, I can't agree to this. We only got one expert. And I say, oh, come on. We've come all this way. We're all here. I've got the contract. How about this, Steve? I've got an idea. Why don't you just go ahead and we'll sign this contract, okay? But let's agree that this contract will only become legally binding if and when this other expert of yours says that this is a good machine. What do you say? Because look, we're all here. What do you say?
Sure, that makes me feel as good as if we were all at the same time.
Perfect. So you sign it and I sign it. Well, now you can probably see this coming. You show the machine to your other expert and he's like, this is a piece of junk. This will never work. This is horrible. And now you're not going to invest. And now you can see this coming, Steve. I get
sued. Yeah. Oh, I was afraid of that.
Exactly. Now what are you going to say though? So when I sue you for breach of contract, what are you going to say? Of course,
that my duty to perform never arose because the condition had not been satisfied.
Exactly right. And then you know what I'm going to say, of course, is, hey, parole evidence rule. That was an agreement. And, it may have been considered contemporaneous because we're all at the table, but I don't care because it's oral. It was an oral contemporaneous agreement that was not included in the writing. And therefore the parole evidence rule discharges. So I'm going to try to do a game of gotcha. Well, here's the good news for you, Steve. You are most likely going to win. At least you're going to defeat my parole evidence rule argument under this so-called conditional delivery exception. And this is the way I like to think about it. I like to think about it is that agreement isn't an integrated agreement because it doesn't include any terms that are final. Because we agreed, we had an oral agreement that those terms wouldn't be final and we wouldn't have a contract unless at all, unless and until that condition occurred and that expert agreed. And so if there is no integrated agreement, there cannot possibly be a parole evidence rule argument, and therefore your oral agreement is admissible. And if you prove we had it and the condition hasn't occurred, no contract forms, and you win. Now, there's one exception. If your oral agreement, because let's make things complicated, right? This is already hard enough. If your oral agreement is expressly contradicted by the terms of the writing, then that agreement is discharged. Now, you may say, what does that mean, expressly contradicted? Well, I don't know. I mean, we could probably debate that. But if the agreement says something like, this agreement is binding immediately upon both parties signing it, and no reference, of course, to any conditions, you're probably in trouble because now it sounds like it's being expressly contradicted. So that is what we call our conditional delivery exception. You may not remember this, Steve, because it's only been like what, like how many years since you were in my contract class?
Gosh, it was 13.
13. You read a case dealing with this. It was a case where it was a guy who agreed to guarantee a loan to a business. And there was like 7, like officers or partners or whatever. And he said, well, I'll do it, but only with the agreement that I'm bound by this if everyone else signs too. Because he didn't want to be like the only one. He's like the first guy, and then it's like no one else signs it, and it's like, okay, yeah, well, you're the sole guarantor. He said we had an oral agreement that this would not be binding on anybody unless and until all 7 people co-signed, and that was allowed. As long as it wasn't expressly contradicted by the writing, that was not discharged by the parole evidence rule because under the so-called oral condition precedent exception.
And that makes sense because if there is an oral condition, how else do you prove it except just allowing a little workaround parole evidence? Otherwise, you couldn't, there'd just be no other way.
There would be, so I guess the counter argument is, well, why'd you sign that thing? What were you thinking? It was 3 a.m. I was at a Denny's. Yeah. The omelet was good. We were all happy,
Nothing good happens at 3 a.m. at Denny's anyway.
Yes, right. So, except the omelet. The food is good at reasonable price, I think, right?
Very reasonable.
Right. So that is a conditional delivery exception. All right. Let's now talk about, we've got an integrated agreement. Whether or not that integrated agreement is going to discharge a prior oral or written promise or agreement, or is going to discharge a contemporaneous oral promise or agreement that wasn't included in the writing. So the big issue here is going to be whether or not the integrated agreement is considered a partial integration or a total integration, also called a complete integration. Is it fair to say, Steve, that bar outlines are littered with discussions of parole, of partial versus total? Is this the name of the game to talk about this on the bar if you have a parole evidence rule issue?
I think you're in good shape if you just have the 1-line definition. I think that's probably enough because you got 23 other subjects to watch out for. So there's only so deep they can make you go.
But you would be, the bar examiners, presumably, if there is a parole evidence rule issue, they're expecting to at least see a reference to total versus partial. Is that fair to say, do you think?
I think so. Depending on the facts, I think what's trying to come in versus what was written, I think that's what I would tell a student to focus on, see, and really question those two things, because, you know, like, I think that'll lead you down to this issue.
So let's head on down to this issue. And I would like to say, though, that there's actually a situation, as you talked about, does the situation lead you down that path? There is a situation in which it, in fact, would not matter if the integration is total or partial. And let me first describe what we mean when we say total versus partial integration. A partial, I should probably start with total, because I think when people think integration, they're thinking total usually. But integration actually doesn't tell you whether it's total or partial. It tells you it's one or the other, but you don't know which one. But I think most students, most people, most lawyers, when they say this is an integrated agreement, they actually are saying they think it's total. Though us law professors, we won't like that. We'll mess with you. Well, total or partial, we'll say. So a total integration is this idea that we believe that the parties have intended to include in the writing everything. It really lines up with your very definition, Steve, when you're talking, sort of, you're describing what an integration is. I can't, I think you're talking about it's complete, it's all coming together. It's this idea that we're taking everything and we're putting it all in this writing. And so there's nothing outside the writing that we're intending to survive. That's what we call by total or partial integration. Probably why people integrate most of the time is to seal it off from anything outside. A partial integration is we believe that the parties intended to integrate and include in this writing terms that were final. So it's not like a status of negotiations letter. It's meant to be final. These terms are meant to be final, and we have a deal. But the law do not think that the parties are intending to include all of the terms of the deal in this writing. That's a partial integration. I received a wonderful question from a student this semester. See, the student said to me, why would parties ever have a partial integration? It doesn't make sense to me, based on what the student was saying. Is if you're integrating, you're going to want to make it total. When would this happen? And I had to think for a second. And this is what I think. There's going to be times where, let's say, there's not a lot of time. Steve, you and I are at Denny's at 3 a.m. or we're at a bar at 3 a.m. Lucy v. Zemmer-ish, our famous case, right, with the sale of the Ferguson farm. And we've talked about a lot of things. Our agreement has had a lot of details. And we want to now get it in writing, but we don't want to get everything in writing. It's late. We don't have a lot of time. We really just care about getting the big ticket items on paper. What's being sold, the Ferguson farm, how much are you paying? And that's really what we most care about. We're not so much worrying about, we're not two lawyers drafting up a big, long, detailed contract. Well, we might do that later, but we just want to get down in writing, memorialize the main parts, because that's really what we care about. Someone coming back and lying and saying, I never agreed to sell the Ferguson farm. We don't care. We're not really worried at 3 a.m. in the bar at Denny's about someone lying about whether or not the one heifer or whatever on the land was included, or the shack across the street was going to be destroyed. So I think there's a lot of reasons why people might willingly choose to enter into an integration that is only partial. So, but now let's talk about when it doesn't matter, whether it's partial or total. If the extrinsic agreement contradicts, is inconsistent with the writing, then the writing supersedes, discharges the extrinsic agreement, whether it is partial or total. So if we decided just to put in there the big ticket items, the reason why we put those big ticket items in there was to make it clear that I was agreeing to sell the Ferguson farm, not my other farm that has another name, and to put the amount of money in there, $50,000, because I didn't want you to come back later and say, our agreement was that you would only pay $40,000 for it. So doesn't it make total sense that whether it's partial or total, if the extrinsic agreement contradicts a term in the writing, the parole evidence rule should come along and discharge that prior agreement?
I think that's the easy part is understanding that. The harder part is determining whether something is really contradicting or not. I think that's sometimes where students can get in the mud.
Oh, you want to go there? Let's go there. You're bringing out, you love, what is it? Hang on. I got to get this phrase. You love, what is it? I got to figure out if it's subtle difficulties or difficult subtleties. Subtle difficulties. That's all. That sounds like our PBS K-Talk show. What do you think? Today on subtle difficulties.
Oh my God. I think that would be great. I'd sign me up.
That would be like our spinoff where we just talk about like really, really like narrow in the weeds, right? It's like, let's talk about this little, footnote 47 kind of stuff, right? Subtle difficulties.
I bet we could get Larry David on that one.
Oh, that would be great. You're right. It seems very, yes, that would be great. So it's not going to be, so you're suggesting this is really just like a comedy show. It's not, you don't know, take it seriously. It's okay. So, all right, let's talk about a subtle difficulty. Listeners, blame Steve, not me for this. There are two approaches to determining whether something is inconsistent. First, a broad concept of inconsistency, and of course, yes, a second narrow concept of inconsistency. And what's interesting is that the view that has a broad view of inconsistency is actually building up the parole evidence rule and discharging more stuff. Because remember, if the extrinsic agreement is inconsistent with a term in the writing, then the parole evidence rule automatically discharges it. You don't ask, you're not talking about natural omission, partial, total. It's over. If it is an integrated agreement and the extrinsic agreement was contemporaneous oral or prior written or oral, it's gone. It is discharged. So the stakes are high. And the narrow view is actually of inconsistency is actually is a more opposed to the parole evidence rule applying because it's going to be harder to discharge it. Okay.
And I think that's the cool thing is just knowing, really questioning as you're reading the facts. And I think that'll help you scoop up those points. If you see an argument that it's not really contradicting, just argue it.
And you want to get some more points? You ready for this? We have a name for the broad concept of inconsistency. Now, my guess is for students who are listening to this for purposes of taking a bar exam, they may want to fast forward. I mean,
Absolutely.
right at this point, right? We should have like little warnings. I should probably have timestamps for people who, right? You can just skip ahead if if it's like the bar exam, you don't have time to have a 2-hour discussion of the parole evidence rule probably because you got 23 subjects to study for, right?
Yeah.
So,
amen.
But so for your students who are contract students and are aiming for that book award, right? And you're willing to get into the weeds, the broad concept of inconsistency is something called the reasonable harmony test. I love this name because the name sounds so nice. Like, oh, reasonable harmony. But the reasonable harmony is awful. It's like building up the parole evidence rule, and the parole evidence rule is a killer. The parole evidence rule destroys and discharges promise. I mean, I tried to make the parole evidence rule seem like a nice guy at the outset, but the reality is the parole evidence rule is on the hunt for extrinsic agreements to discharge them. He's not a nice guy at all. And so when you have a broad concept of inconsistency, you are empowering the parole evidence rule more than the other view of inconsistency, and it's destroying more promises and agreements. And so, yeah, you can call it the reasonable harmony test. Sounds beautiful, but it is actually discharging more promises. I think it's like literally like the Greenland business. Didn't they say name it Greenland, right? Like, or, oh wait, or was it no green? Oh no, green was the opposite. Green. You want to make it think was nice or something like that, and people would come, and it was bad. I don't know. I can't remember. I can't. It doesn't. None of that makes any sense. But here's a reasonable harmony test. If the court believes that the extrinsic agreement, that there is not reasonable harmony between the extrinsic agreement and the terms in the writing, then the extrinsic agreement and the writing are inconsistent. Whereas under the other narrow approach, it would have to be more expressly inconsistent, like 35,000 is inconsistent with 45,000. I'll give you an example of the reasonable harmony test, because I know this one, a lot of listeners are like, okay, what? I don't care. But let me give you an example where it actually really matters. Oral conditions to a duty to perform. Let's go back to the steel case. I promise to sell you steel, and we have a written integrated agreement. But I allege we had an oral agreement that if I couldn't get the steel, that from my supplier, that my duty would not mature. Basically, I would have no duty to give you the steel. And the question then is this discharged by the parole evidence rule? Well, if the oral agreement is inconsistent, if the oral condition to my duty to perform is inconsistent with the writing, it doesn't even matter if that is a partial integration because it's discharged. If it is not inconsistent, well, then let's talk about whether it's total or partial. And if the writing's kind of skimpy, it doesn't have a lot of terms, maybe you can argue, look, it's not a total, it's just a partial. Under the reasonable harmony test, courts are generally going to say that a condition on a duty to perform, there is not reasonable harmony between those two. That if I promise to deliver you steel, and on its face in the writing, that promise is unconditional. I promise to deliver you steel, period. No mention of any conditions. The reasonable harmony crowd is going to say, look, there's not reasonable harmony between a promise to get steel and a promise to get steel only if. And think about it. If I promised my daughter that I would take her to a theme park, I promised to take you to a theme park on Tuesday. And on Tuesday morning, I say, oh, by the way, I can't do it because I've got a meeting at the office. She's going to think that this is very inconsistent with what I promised her. I promised her X. It was unqualified. It was absolute. I didn't promise her X only if. She will view that as very inconsistent. The express condition, the crowd and the courts, which are looking for more express conflict and inconsistency, are more apt to say, we don't think it's inconsistent. We think that having a qualification is not that directly conflicting and inconsistent. And so we're going to ask, is it a total or a partial? So that's actually where this differing view can have a lot of effect, is when you're dealing with conditions to a party's duty to perform that on the face of the integrated agreement was unqualified. Are you asleep? Wait, Steve, are you there? Steve.
I'm loving it. I'm loving it. And I'll tell you why I'm loving it. Because I want to remind the listeners, this is about spotting the issue and arguing both sides. And you generally don't have to be right. Because I think this is one of those situations where you can get a lot of points as long as you don't stress yourself out thinking that there's a right answer on this.
Yeah. So if a student asked me, well, Professor, which one applies on the final, which honestly is a reasonable question, reasonable harmony or the narrow view of inconsistency? I mean, I'd be facetious when I say this, but like, I don't know. What do you mean you don't know? You're the professor. I'm going to the dean. You got to tell us. I would be facetious, but and then of course I would quickly follow that up with is like, look, you know, in most essays, you're not applying the law of any particular state. I mean, that may happen. But most professors, it's just some random jurisdiction. You assume that they don't know if the law conflicts, they haven't picked a test. And yeah, and as you mentioned, Steve, they should point out both of these if you got time to do it and argue it could go either way. But yeah, I assume on a bar essay, if you're talking about the reasonable harmony test, you're probably going to be running out of time.
Oh, absolutely. Yes, absolutely.
Don't do it. Okay, let's now talk about a situation where the extrinsic agreement does not contradict the terms in the writing. Under whatever test the court has applied to determine inconsistency, the court has determined it's not inconsistent. I think this is probably where most of the parole evidence rule issues, say on the bar exam or on a law school exam, will land. They will land here. We've been doing a lot of talk, but really they end up here, I think, don't they? Which you got a term that would supplement, not contradict. I promise to destroy the ice house. The contract is silent on whether I'm going to destroy the ice house. And the question now is it a partial or is it a total? That'll help determine whether or not the parole evidence rule is going to discharge it. Is that fair to say? Do you think this is usually where the issues will land?
I think so. This is your run-of-the-mill parole evidence issue.
Yep. If there is such a thing, of course. But your run-of-the-mill is still a challenge. So if a writing is a partial integration, it only discharges extrinsic agreements that are inconsistent, not ones that are consistent and that would supplement the terms in the writing. If it is a total integration, it discharges all extrinsic agreements that are within the scope of the writing, which is generally considered very broad. So basically, it's discharging everything. It's not discharging something that's totally unrelated. I mean, that wouldn't make any sense. But it's basically, it's going to discharge pretty much everything that is considered related to the subject matter of the writing. So the stakes are quite high as to whether or not a writing is deemed a partial integration or a total integration. So let's talk about how one goes about determining whether or not a writing is a partial integration or a total integration. First, we've got an easy one, Steve. So this is nice. This is sort of the land of probably multiple choice questions. If the extrinsic agreement had its own separate consideration, it is not discharged. It lives. And that necessarily would mean that the writing is partial. You kind of back into the decision is partial. But once you see an extrinsic agreement that has separate consideration, that agreement is going to live. It's not discharged by the parole evidence rule. And let's use this ice house example. And the students may say, well, why are you talking about this ice house? What's this? What is an ice house? Gorman, what are you, 150 years old? What's an ice house? This comes from, Steve, as you may remember, Mitchell versus Laff, a famous case decided by the New York Court of Appeals in the early 20th century, where I am selling you a parcel of land. I own the ice house across the street, and you, buyer, find it objectionable. You only want to buy my parcel of land if I also agree to remove this ice house. And I agree. We then enter into a signed written contract. It doesn't have to be signed to be integrated, as we know, but we enter into an integrated agreement for the sale of the parcel, but it omits the agreement that I will destroy the ice house. And of course, you can see this coming. You take possession of the land, you got the deed. I refuse to destroy the ice house. You sue me for breach of contract. I argue that the ice house promise was discharged under the parole evidence rule. It's presumably not inconsistent with the writing. We could try to talk about reasonable harmony on this, but let's just assume it was not inconsistent. There's nothing in there saying that I'm not going to destroy the ice house. And now the question is, okay, is this a total integration or is this a partial integration? Let's say, Steve, that this side agreement had included me destroying the ice house and you agreeing to pay me an extra $200 on top of the price to buy the land. That agreement would now not be discharged by the parole evidence rule, because that, you call it a collateral agreement if you want. I mean, it's kind of a loaded term. A lot of people use that phrase, collateral contract, for different things. But let's say that we will call that a collateral contract in the sense that it has its own separate consideration. It's not discharged. Take that to the bank. Our statement tells us automatically, if it's within the scope of the written agreement, necessarily that's going to make the written agreement a partial integration. Even if there's a merger clause, I don't care. Separate consideration, it's going to survive. And students say, well, when wouldn't you have separate consideration? Well, the consideration wouldn't be separate if you promised to buy the land in exchange for my promise to destroy the ice house, and there was no extra payment by you. So the sole consideration that you're giving in exchange for my promise to destroy the ice house is you promised to enter into this under this contract with me to buy the land. That's a problem. Now we got to keep going with our analysis. We don't know if it's partial or total, but if there is this separate side consideration, it's automatically survives and automatically makes the integration partial.
And that kind of makes sense, because if somebody's paying some extra consideration, that seems to kind of evidence intent to keep that agreement alive.
Exactly right. I think there's a lot of ways that you could come at this. You could come at it saying, well, it's natural to omit it. It's not within the scope of the writing. Lots of different semantic ways to reach this result. But the result we know is that all roads end to it's not discharged by the parole evidence rule. So let's talk about a situation then where there is no separate consideration for it. And we're still trying to figure out now, it's still in play as to whether it's partial, because the lack of separate consideration means it is still potentially a total integration and therefore discharge. What the restatement says, I'm going to follow the restatement here. And the parole evidence rule is a mess, Steve. It's a mess. It's a mess across jurisdictions. It's very difficult to understand what courts are doing. If you open up a horn book, it's probably going to tell you about all these different tests: the Williston test, the Corbin test, the restatement, the first restatement test, the second restatement test. It's horrible. And there are some professors that will talk about this, but my guess is that if you are, I mean, I don't know, you tell me, if I'm getting ready for the bar exam and I'm thinking about the Corbin test and a Williston test for the parole evidence rule, is that maybe not a great idea?
Yeah, absolutely. Stay away from it. Just keep your general parole evidence rule and get in and get out.
Probably any time that you're studying for the bar exam and someone's trying to help you and they say, Samuel Williston wants that, it's probably bad, right? I mean, I don't know. I mean, I could be wrong. I mean, I don't know.
I think so. But if you're that type of person who can't wait till the third restatement of contracts comes out, God bless you. You're a taller order of intellect than I'll ever be. My
understanding is there's no, I mean, last time I spoke to somebody at a conference who was in the know, and I said, was there any talk about a third restatement? It was the daughter of one of the reporters for the second restatement, and she sadly passed at a young age. But I remember asking her, saying, is there any talk about a third restatement? And she told me no. And what I love about contract law is that, it's been, 40 years since the last restatement. Why would we need a new one? Only been 40 years. I mean, come on. 40
years is just a blink of the eye of contract law, right?
It's nothing. I mean, talk to me in 100, maybe we'll think about it. Of course, I say that and someone will post in the comments, let's talk about a third restatement. So let's talk about, let's not talk about Williston, Corbin, though if your professor's talking about it, then it's probably a good idea to know about it. And there's nothing wrong with your professor talking about that, because there is a lot of differences of opinion on the parole evidence rules. There's, just like with the inconsistency, some courts apply this test, other apply this. And if your professors go in there, you go there. But I try to avoid it. But I pick the restatement. I mean, even I have to choose, right? I mean, so I'm sort of a hypocrite here, because you got to pick a test. You can't just be like, well, this is the test. If there's a bunch of tests out there, you got to kind of be wedded to one. And I picked the second restatement. So what the second restatement says is, if it would be natural. Oh, you got to love this. It's like, oh, this is going to be clear. This clearly, I mean, this is a rule, not a standard, right? If it would be natural to omit the term, meaning at the time of integration, if it was natural to omit the term from the writing, then it is necessarily a partial integration. Because if it's natural to omit the term, then it would be reasonable to believe that the parties did not intend the writing to include everything. You're kind of backing into it. If it's natural to leave it out, we must believe that the parties intended this not to be complete, and therefore it's partial. And therefore, as long as it's not inconsistent, if it was natural to omit the term at the time you integrated, then it's a partial integration and it's not superseded because it's not inconsistent. Yeah, yes.
That makes perfect sense to me, but
So, and a lot of courts will talk about the so-called natural omission test. Okay, so let's talk about the way the restatement talks about the natural omission test. The restatement actually doesn't talk a lot about it and has very few examples of this occurring. But the way I like to think about the natural omission test, and I think the way the restatement thinks about it is, the restatement is talking about what natural to omit, not meaning it's natural for these parties to omit, but natural for the reasonable person to have omitted. That it's an objective test, that even you bring out the reasonable person who, Steve, the reasonable person is dressed like us, right? The reasonable person, they probably have not, the reasonable person is like, where's your tie? I don't know, we're quite up to par, but up to standards. The reasonable person, if the reasonable person was brought out, and even the reasonable person was like, yeah, I think it would be, I understand why the parties would exclude this term. And while they're intending this to still remain part of the deal and not be superseded by the writing, if the reasonable person says that, well, then, wow, we're fine. It's a partial integration, because even the reasonable person is like, yeah, I could see why that would have been left out. The only real example I recall the statement gives of a situation which objectively it would be natural to omit a term. The example they give is when you have a standardized contract, a form contract, and the agreement relates to a term that does not really have a place in the standard form contract. So let's say that an association of realtors has prepared a form real estate contract, and you just plug in, it's on Adobe, whatever, and you just plug in some blanks, and there's a price blank, there's like a land description, and that's it. And I know this gets a little weirder now because it's so easy to add stuff today in the age of Adobe and Microsoft Word and word processing. But I think it was this idea, particularly maybe before all that I would print out a form contract, and there wasn't really any space to fill in other terms. And so if we had an agreement, let's say, where I was going to destroy the ice house across the street, but we agreed, and our agreement was in the form of this stock real estate agreement, there's probably not a space in there to talk about destroying something across the street. And so even the reasonable person would be like, yeah, presumably, I mean, this is the argument anyway, it would make sense that it would be natural to omit that term from the writing because it really doesn't have a space in this form contract. That's the restatement example. So
it's funny because I was imagining a form contract as you were talking about the rule, thinking that is a situation where, who handwrites on one of those to put something like destroying an ice house? Like, I just don't see it happening. So that I can't think of any other situation where that might arise.
And what I like about this is this shows that the reasonable guy is he's not as unreasonable as we may suspect. I've always had a suspicion about the reasonable person. I think I got this from torts, though, not contracts, though there's a little bit of it going on with contracts with the duty to read rule. This idea that the reasonable person is not very reasonable. I remember my torts professor, I had a torts professor, Bill Nelson, who was just an amazing professor. And I think I remember him saying to the effect of, and don't quote me on this because I'm not sure he said it, but something about how, is a reasonable person a little bit like overly, too reasonable? Does he walk into the room and like check to make sure it's not toxic gas. And he's like checking the floor. And I don't know, I'm not a torts professor, so I'm probably overstating it, but it was this idea that the reasonably prudent person in tort law might be like, wow, is anybody really that guy? And if that is the reasonable person concept often, and I don't know that it is, but I think it is sort of maybe with the duty to read rule, right? The duty to read rule in contracts is, look, it was on page 40. Why don't you read page 40? And if that is the concept of the reasonable person, I think it's nice to see here that with the natural omission test, the reasonable person, there actually is some situations where the reasonable person would say, yeah, it would be natural to not include that term in the form contract. Because I could see the reasonable person being a bit of a jerk and saying, why didn't you you don't have a pen, kiddo? Who doesn't carry a pen to a closing, kiddo? I always carry a pen to a closing, right?
Right. A little neurotic, afraid of everything. But exactly. No, I agree with you. This is a little human, reasonable person.
It is. It's nice to see he's got a little bit of a heart, So now let's talk about, and I would tell you, a lot of courts, and I used to teach it this way, we'll use this natural omission test as basically like the test. Like once you're here is like, is it natural to omit or not? Was it understandable to omit or not? The restatement seems to divide up an objective test here and a subjective test. So then the restatement is second restatement is very new school in this, right? Anytime you talk about subjective, we generally don't like that in contract law. That's old school business for the subjective. And if you're talking subjective, it's loosening things up a little bit and going a little bit new school. And the restatement, as best I read it, is that the natural omission test is more this objective. Would even the reasonable person have excluded, felt it natural to exclude? And the restatement is then going to say, yes, but we're not, even if the reasonable person would have included it and say it's not natural to have omitted it, we're still going to ask, do we think the parties intended this to include everything, or did they intend this outside term to survive and not be discharged by the writing? A very personalized analysis and contextual analysis focusing on the parties. But let me mention one thing before we leave the natural omission test, because the students get all turned around on this. The question isn't, is it natural to include the term or not at the point of a lawsuit? The question is, was it natural to omit or to include the term at the time of integration? So if it would have been, because students often think, well, if it's natural to omit it, that means it's not in the contract, it's discharged. And if it's natural to include it, well, let's include it and enforce it. They've gotten completely turned around 180 degrees because they're focusing on the wrong time period, asking when is it natural to include or omit. The question is, on the natural omission test, is at the time of integration, when we inked this thing, was it natural at that point to omit the term from the writing and still intend it to be part of the deal? Or would it have been natural to include it if we intended it to be part of the deal? So if it was natural to omit it at the time of the integration, it's not discharged. It remains part of our deal and is enforceable. If it would have been natural at the time of integration to include it, then it is discharged because we assume the parties must have intended to supersede it, and it is not part of our deal and can't be enforced. Confusing enough?
Yes, Parol. This is why it's the dark art that it is.
The dark arts. Oh, so I'm like Snape. Is that what you're saying? Snape. Yeah. So, all right. So yeah, it's a very special K Talk, right? It was hosted by Snape. And I guess, are you Lucius Malfoy? Is that who you are?
I'll take it. It's an
honor.
Take it.
Or Bellatrix. She's great, right? She's great. She was Slytherin for sure, wasn't she? Let's talk about now a situation in which, let's figure out where we are. We've got an integrated agreement. We are dealing with a contemporaneous oral or prior written or oral agreement. It is not inconsistent with the writing. So we are now asking if we're now asking if it is a partial or total integration. It was not given, the separate extrinsic agreement was not given for consideration separate from entering into the contract. So it is not what we may call a collateral agreement. It is something that the reasonable person would have included. The reasonable person does not think this was something that would naturally be omitted, not by him or her anyway. And now, boy, if you want that ice house promise to survive, you're struggling. You only got one shot left to have this be a partial integration. And that is to convince the court that the parties did not intend this to be a total integration. They intended it to be a partial integration. Now, that process may be different from what your professor is talking about. You may never hear about subjective intent, so go with what your professor says. But the restatement has this one sort of last final chance in looking at the subjective. And so the question now is, what kind of things are important to try to decide whether or not we think the parties intended this to be partial or total, intended it to be superseded? We're not just going to let somebody say, when we say we're trying to figure out the subjective, that doesn't mean we're just going to like take what they say as true. Are you kidding me? We're still going to look at objective manifestations to try to figure out what we think they intended. So the things we're going to look at, they're still manifestations and outward evidence of intent. If that makes sense, we might be trying to get at what we think they intended, but we're still trying to do it based upon what they said and did at the time. And here are the big three. They're going to be factors. I've been a boo. We hate factors. There's going to be a lot of factors, but these are the big three. If you're talking about a parole evidence rule issue and you are talking about it's not inconsistent and you're here, I think at a minimum, you should talk about these three on a law school exam. I'll let you chime in on how important it is for the bar exam. Number one, how detailed is the integration? Does it have a lot of terms or is it skimpy? Are there references in the writing to extrinsic agreements per other agreement? Are there blanks? So if it's skimpy or it has references to other agreements or it has blanks, this is all, of course, a very important factor pushing toward parties did not intend this to be a total integration. If it is a thick contract, oozing with detail, no blanks, no references to other agreements, then this is pushing strongly toward it being a total integration. As a matter of fact, there's an older test. It's called the appearance test, which if it appeared on its face, this is all you do. If it appeared on its face to be total, it was total. Now, the restatement rejects that, so I don't teach that, but you may have learned that in your contract law class, this appearance test, which is it was the all or nothing. It's very old school. But so that's factor number one. Factor number two is how closely connected is the extrinsic agreement to the terms in the writing. The more closely connected they are, the more related they seem, the more likely it is that we would think that the writing includes everything. Because if it's closely connected, we would have thought they would have included it. The more attenuated, the more loosely connected it is, that pushes towards saying this is a partial integration because it sort of makes sense that, well, it probably wouldn't have included that in there. So here you're seeing a little bit of like overlap, maybe with the natural omission test, perhaps. And third, oh, and this is a biggie. I know you know what's coming. Here it comes. Is there a merger clause, a so-called integration clause, a clause in the contract in which the parties actually say and agree that the terms in the writing are everything? Merger clause usually says something like the parties agree that the terms set forth in this writing are all of the terms of our deal and there are no extrinsic agreements. Boom. Those are your big three factors if you can remember any, because there's others, how sophisticated are the parties? Was the relationship of trust? Does the deal seem absurd without this term? But the big three are those. And I think those are always the ones you just want to look for and talk about if they're there.
Yeah, and on the bar exam, the two that I've seen tested in Florida are the first and the third. So the level of detail and how comprehensive the agreement is. Like if you see facts about that, if on the bar exam, they're not big on including the entire agreement, but I think on the exam, they're much, much more likely to include a merger clause and not call it a merger clause, but you need to supply that term. But that I do see a merger clause as probably the biggest one for the Florida bar exam.
And I think that would be, a significant oversight, that if there was a merger clause, one of those things, again, you're driving home from the bar. I don't want to upset people. He said it on the podcast that it happened. It's his fault. You're driving home from the bar exam. You're like, you're talking to your friend, like, oh yeah, did you get the merger clause?
Yeah.
Merger clause? What? Oh my God, there's a merger clause. I totally overlooked that because stuff is under time constraints. It's very easy to overlook little things, especially when they don't say it's a merger clause, right?
And I think even more common is you see the merger clause in the fact pattern, but you forget where it belongs in all of contract law. And if you think of the parole evidence rule, you're not in trouble. You've got it. But it's just too many things in your head and not enough practice applying them. And I think that's really how you learn parole evidence, is doing a bunch of problems, because just trying to understand it and read it and get it is really, really hard. It's virtually impossible to do.
I mean, and that goes for so many of these things, right? I mean, I think, the most important thing, like if my daughter went to law school, what I would tell her is, you've got to do practice multiple choice questions. You got to do practice essays. Don't wait until close to the exam to use those to see if you're getting, if you, where you're at. Do it, use practice questions, actually learn the material. Start doing practice questions when you feel like you don't understand the material well, because it just seems to me that's the way you learn, is by applying it. And so I agree completely with you. Now, what's interesting to me about merger clauses is that students let's say you're studying merger clauses, the parole evidence rule, after you've done interpretation, though I actually teach it before interpretation. But if you're doing it after interpretation, you might be screaming, because you're saying, well, wait a second, it's a term of the deal. The party had a duty to read. I don't care whether they knew there was a merger clause in there or not. It's in the contract. It's not ambiguous. I mean, merger clauses often aren't ambiguous. Sometimes they could be, but if it's a well-written merger clause, it's comprehensive. It's trying to destroy everything. And students will be confused. They'll say, well, wait a second. I don't understand. Number one, the parties agreed that it was total. So why are we not honoring their agreement? Number two, I don't care. We don't care if the party we don't care if the party read the contract or not. Duty to read rule. And number three, doesn't in some respects a merger clause make every extrinsic term within the merger clause, the scope of the merger clause, inconsistent with the writing, and therefore automatically get discharged? Those are all fair arguments. But the reality is, the truth is, for most courts, and this is probably more new school, but for most courts, a merger clause is not considered dispositive, meaning that simply because the parties have included a merger clause, and yes, there was a duty to read. And so, yes, we're not saying it's not part of the contract. It is part of the contract. That does not mean most courts are not going to, or at least under their statement in the modern view, are not going to consider the merger clause a slam dunk. And students might be bothered by this. But what we're seeing is, we're seeing courts not wanting to see games of gotcha. So it's a little bit of the softening of this, the reasonable person should know everything. It's this idea that if you are somebody who's unsophisticated and you're promised something, right, as part of this deal, and then I slide over a very long standard form contract to you, and you don't read it, because you're not sophisticated, you're in a hurry, and you're trusting me, and you sign it. Now, you may be in big trouble under the parole evidence rule, and you're going to be in big trouble that there's a merger clause in there, but we don't feel like it should be an automatic killer. You should at least be able to try to argue, it should be a fact. It's a very strong factor. Merger clause, getting out from underneath the merger clause is not easy, even when it's not dispositive. It's got tons of weight to it. And so it's going to be very hard. But if you're unsophisticated and it's a form contract, it's on page 40, there's a chance that the court's going to say, we don't think the parties intended that prior agreement to be superseded by the writing, even though there's a merger clause, because we just think it's boilerplate. So, but that's the most interesting thing about it is students are probably tempted to say the merger clause is an absolute killer based on what they've been taught about the duty to read rule interpretation. And it's for the modern rules, it's not the case.
It's so interesting because it's a little bit of subjective intent just popping into contract law as rarely as that happens. I just feel it right here.
Absolutely. And, when we start getting to defenses, students need to appreciate that too, right? With like making mistakes, we're going to start getting into, there is going to be pockets of the subjective. And it tends to be a very new school thing where perhaps we've decided that going, do you really want to be the radio station that we're 24 hours, 7 days a week objective? Nothing but objective, right? I mean, don't you want a little variety every now and at least on like holidays? Can't we go? Do we even got to go objective on holidays?
And I think it's one of those principles of where, usually there's no crying in contracts, but sometimes you just have a little moment where you shed a little tear.
Yeah, because you're right. We say there's no crying in contracts. Even your, what I consider anyway, famous statement is look, subject to an exception, right? Because we know that you can get emotional disturbance damages in some cases. We'll talk about that with remedies, kind of like this famous death rule or dead body rule, where, the mortuary drops the casket and heralds your husband, ex-husband, right? He's all over the floor. There's going to be exceptions even to your famous statement that there's no crying. It's no crying in contracts, asterisk. So right. The objective theory has an asterisk, except in Maine and Hawaii, whatever, right? Usually West Coast, except in California, So let me just quickly mention, because I feel an obligation, just mention some of the other factors. And then I thought maybe what we do is we end this very long podcast just quickly talking about the Mitchell versus Last Famous case as to how this might apply. But so the party sophistication is relevant at this point. If you're very sophisticated, both parties, we're going to assume you probably intended this to be a total integration. If you're just two guys at a bar writing up something to sell a parcel of land, less likely it's a total integration. How long you spent on the writing? If you spent a week on it, we probably think you intended it to be total. If you drafted it up at 3 a.m. at a Denny's in 15 minutes, probably going to be more likely pushing toward partial. What I think would be hilarious if you had it on a napkin at Denny's, but it had a merger clause. That would be weird.
Written in blood.
Written in blood with a merger clause. Well, that's interesting. The formality or informality of the setting. Aha. So if it's Denny's 3 a.m., that's just a factor. Remember, factors are things on the scale that push one way or another. They're not dispositive. They're not elements. You don't have to have them. And they're not always in play in every case. But the formality of the setting. So 3 a.m. at a Denny's versus 3 p.m. at a law firm. That's a factor as to whether you think the parties intended it to be total or not. The degree of trust between the parties. If it's, Steve, we're friends and we write it up, I'm not intending this to be total, because you put it in writing typically because you don't trust the other side. But if you got trust, we're probably not doing this necessarily to get everything in there, maybe just to commemorate or memorialize. I should not commemorate. That's a celebration, I think, isn't it? To memorialize the terms so we don't forget it, not because we don't trust that we're going to not perform some of these other parts of the deal that we had. The industry practice, is it typically do parties include this type of term? So if this type of term that's in the industry commonly leaves it out. This is basically evidence that, well, maybe these parties probably didn't intend, if they're familiar with the industry standards, probably didn't intend this to be everything. And the term's importance. But this is a tricky one. Students always say, well, if it's an important, they go both ways, actually. Well, if it's an important term, then I'm going to say it's discharged, because then they would have included a term that's important. And then other students say, well, it's an important term, so they wouldn't have let it go, because why would they let go an important term? So you see how it can go both ways. So I spent time trying to figure this out because it bothered me. This is what I think it comes down to. If it's a term that's important, but the deal still makes sense without it, I think that supports the argument that the parties probably didn't intend to include it, because you tend to include important terms. You're going to put it down in writing. If you're going to integrate, it makes sense to include the big ticket items. So if it's something big ticket item, you didn't include it, you probably intended it to go. But if it's so important that the terms of the deal would make little sense without it, you probably didn't include it to be total, because why would you have a deal that makes little sense? If that's my reconciliation, if that makes sense. But there's all those factors. But remember your big three, those are the most important. So Mitchell versus Lath, the Ice House case, this is a wonderful case, because it is a case in which there was a majority and a dissent. So the problem is to destroy the ice house across the street. The majority says the parole evidence rule discharged it because they believe it was closely connected. No, they're grabbing a factor of those big three. There was no merger clause, so they didn't talk about that. Though arguably the lack of a merger clause can be used as evidence that they didn't intend to be total, like a negative. Like, hey, there's no merger clause. So wasn't that, it looks like it's intended to be partial. They didn't talk, they talked about the writing appeared comprehensive. It talked all about the terms of the land sale deal. So it was detailed. So that was a factor for the majority. And in addition, they felt that the connection was close because it's right across the street, presumably it deals with the view. And so they felt that the factors pushed toward discharge, total integration. The dissent said, well, wait a second. They didn't say lack of merger clause. I would have said that. Number one, yeah, it may have been detailed, but it was detailed about the land sale. It was everything about that land that was being sold. It wasn't, the contract was a basic contract for the sale of a parcel of land. And this was talking about something else. So it wasn't like detailed about everything that could possibly happen. It just seemed detailed about, it was detailed about a subset of the deal. And next, the dissent didn't think it was closely connected, but it was loosely connected because it was across the street. And it was literally dealing with a separate parcel of land. So as you can see, reasonable people, I think both the majority and the dissent they're all reasonable. Reasonable persons can disagree on what they thought the parties intended. Majority felt the parties likely intended this to be everything and it was discharged. The dissent likely thought that it was likely that they did not intend it to be discharged, or perhaps that it was natural to omit it because there was more than natural omission test back then. It was kind of was a prominent test back then. Talking more that language. Majority was more like, hey, it wouldn't be natural to omit this. The dissent was more, it was natural to omit this. But so as you can see, on the same facts, courts can disagree, which of course leads to argue both sides on a close call like that on an essay question.
Which is just points. Don't stress yourselves out. I think that's a great, great moral of the story.
Indeed. Steve, any final thoughts before we bring this darkest of episodes of K-Talk to an end?
I do have one final thought, and that is have a quick and dirty parole evidence rule in your outline so that you don't get lost in the sea of material, because there's a lot. This is a robust principle, but really commit to memory a basic one-line definition of parole evidence, of the parole evidence rule, so that you can recite it from memory using the legal terms of art, and you will be okay. Start there and then move out to all these other aspects of the rule.
And I assume the moving out is more of a law school exam strategy than a bar exam strategy when you're under time constraints, correct?
Yes, absolutely. And I figure, just from having been one of your students, I know it's helpful to orient the general rule first, get comfortable with that, understand it, make each word mean something to you. If it's just memorizing and you don't really know how it operates or what it means, you're in trouble. Back up and make sense of every part of that general rule, then memorize it, but have your quick and dirty definition down, and then begin to increase your comprehensive on some of the sub issues.
And I guess some of the sub issues for a bar exam might be more relevant on a multiple choice portion, I assume, like an MBE contracts. Maybe you get some, I don't know, maybe get some of separate consideration. But so, I guess let me give you a couple lines, I guess, that I would think about writing on an essay on a bar exam. And you tell me if that would sort of would check the box in your opinion. I mean, the first thing, of course, is being able to spot the parole evidence rule issue. I mean, that really is sort of the key issue, right? I mean, you're miles ahead on a bar exam and on a law school if you simply spot the issue, correct?
Oh my God, that's the whole issue on the MBE, on the multiple choice portion. That's the name of the game, because they'll have distractor. The distractor will be about modification or anticipatory repudiation or parole evidence rule. And all you have to do is see the parole evidence rule and you know which answer it is. And the others are just distractors trying to get you turned around, or there won't be a writing, and the distractor is the parole evidence rule. And so you can kind of all you have to do is see the issue on the MBE. That's a little bit lower bar, in my opinion, than an essay where you actually have to IRAC it and work it out. And for the listeners who are saying, oh my God, that parole evidence rule is so intimidating, take a couple of parole evidence multiple choice questions, cover up the answer choices, and IRAC an essay response to it. Force yourself to do that so that you can kind of really work through the logical steps to use the doctrine appropriately and get a rule out actively. Because you can read and think you're really, really smart when you read and reread, but then you find yourself stupid when you have a problem. And that is natural, and that is part of the learning process. Do that inside and out with parole evidence.
It reminds me of when people say, well, I understand it, I just can't explain it. The reality is, if you can't explain it, you probably don't understand it. So for the doing or the explaining can be humbling, because it discloses to you that you may think you know it, but you don't. So I guess I think it can be done on a few sentences. The next issue is whether or not the promise to destroy the ice house was discharged by the parole evidence rule. The parole evidence rule provides that if there is a written agreement, I probably can get away without even using the word integrated. I'm probably okay, right? A written agreement in general discharges, any agreements before it that weren't included in it. If it's a total integration, it discharges everything. If it's a partial, if it's inconsistent, here it's arguable that the ICE, that this was a total integration because it's got a lot of detail, and it has a merger clause, which generally means it's total and therefore would be discharged. Next, and moving on to the next issue.
Perfect. And I'm so glad you provided that, because I think that's a really good place for students to begin.
Yes. And then if you're on my exam, keep going.
Yep, exactly.
Get into the subtler difficulties. So, all right. And so this has been an episode of subtler difficult, or was it subtle difficulty? No, this is not an episode. This is an episode. It's been an episode of K-Talk. We are going to close the book on this dark chapter. Hope you enjoyed it and survived it. We will see you next time on K-Talk.